Hello, everyone. This is Toni Moore, also known as the Boss Builder. I wanted to just have a conversation with you about the need to think before you ink. And when I say think before you ink, I'm not just talking about incorporating, because that's a good policy and a good practice is to think before you incorporate or start an LLC or a church or a business or an association or a joint venture with other people. But today I'm talking about the inking process before you put your signature, your John Hancock, if you will, to an agreement with someone else who has a program in place or has a business in place or have a service in place, and they're willing to provide for you so long as you sign your name and you ink, and you bind yourself to them. So before you bind yourself to them, I want you to think before you ink. And think is an acronym. So the T and think is obviously think. You need to know what you're working with. You need to know the pros, the cons. You need to know who you're working with. You need to think about the good things that could happen and also think about the worst case scenario. Sometimes people call me up and ask me about prenups. But, even with business, if you are going to work with other people, if you're going to have and hold them, if you're going to commit to them for a long-term time, then you need to maybe have a business nub so that you can know and appreciate what will happen just in case the worst case scenario happens. The worst case scenario happens. Who gets the trademark? Who gets the business? Who gets the customer base? Who gets the mailing list? Who gets to keep the office? You know what I mean? Who gets to keep the inventory and the supplies? That's something that needs to be conversed before you ink, before you say yes. Okay. So the next is the H is for to have a policy in place. When you have a policy in place, you pretty much simplify a lot of things, which is good. And when by simplifying a lot of things, what I mean is that you know about the tax policy, you know about the gifting policy, you know about the reimbursement policy, also the conflict of interest policy. And when you have policies in place, then there's no question. It becomes usual and customary. So for me, I always tell my clients to have a policy in place where whenever someone contracts them for their business or services or their products, get them to sign a contract. When you get people to sign a contract, there's no ifs, ands, or buts. It's usual and customary. You're protecting your assets, but more importantly, you're setting the terms and you're letting people know based on the terms of your agreement, this is what you're going to do and this is what you're going to charge. So when you have a policy in place, no one can really refute that because if your policy is, oh, by the way, I'm going to get you to contract this information, or I'm going to send out a standard email verifying our agreement, then that works. Because when you have a policy in place, another policy would be to have people not only have a contract, but initial certain areas, certain key terms that you know works for you. So, with regards to policy in place, another thing that you need to remember is the I is for inspect everything, investigate everything, seek to know whatever you need to know so that at the end of the day, you're not surprised. When you investigate who you're working with, who their alliances are, who their customer base is, whether or not they've been sued. You know what I mean? What type of business do they have? What type of business reputation? What does their brand say? You need to investigate all of that. You need to know the strengths, you need to know the weaknesses, the opposition, and also any threats or triggers. You know what I mean? Because when you start working with other people and you put your brand with their brand, then guess what? If something happens, you could possibly get sued. And you don't necessarily want to get sued because you didn't investigate. So certain things can be avoided when you're proactive to protect your assets. Uh, for the in, that would be the necessary things that you need to know. We already investigate the who, what, when, where, and you already investigate, the strengths, the weaknesses, the opposition, and the threats. But you also need to have certain things in place in your contract. Like with regards to your contract should have maybe an arbitration clause or a mediation clause or some sort of dispute resolution clause, just in case something happens. Another thing that you necessary terms would be whether or not are going to allow someone to assign your contractual agreement so that one day you're working with another person and the next day you could be working with someone else. And if that's not the way you do business, because that's not how I do business, then you need to make sure that that's in your agreement. That is non assignable. Another thing, what jurisdiction? If there's ever a dispute, do you want to be able to say, this is where I want to have our dispute, our conversation? Whatever your state is in, oftentimes you want to bring people to your state so you don't have to go out to other people's state just in case somebody violates your agreement. Okay. And another term is an indemnification clause. That's something that's necessary, because if you're having a joint venture with other people and and they mess up and you get sued because you were operating in good faith and some reason they did something, then you want an indemnification clause, meaning that if for whatever reason you get sued because once you partner with other people you're jointly and severally liable, then you want to have an indemnification clause to ensure that if something happens you can get your money back. Okay. um and lastly, the K in think is knowledge, because knowledge is powerful. It's powerful enough to help you know better and to do better and to seek better. And when you know what you're working with, then you have better footing as to what decision you're going to make for you. And when you know what you're working with, and if it's not a good fit, it's not a good fit. You cannot put yourself in a situation, you should not put yourself in a situation where it doesn't work for you, because you are the boss of your life and your story, and also your destiny, and also your legacy, and also your brand. So you need to know what you need to know so that ultimately the good works for you, and the bad that could have been against you is demonized, meaning that it gets smaller and smaller and smaller because you did everything that you need to do proactively, and you did it confidently, and you protected your assets along the way. Alrighty, so this is Toni Moore, and I just gave you the 5 factor chat on think before you eat. Hopefully that worked. If this was helpful, please share my YouTube video. Please feel free to subscribe, because I always talk about legal chats and I always talk about confidence. Because when you are confident in who you are and whose you are, and you are confident in negotiating by strength as opposed to weakness, then you do whatever you need to do, and you stand up for you and you speak up for you, and you will think before you ink for you. Thank you so much, and I'll talk to you later.